What is going on, my government and politics students? It's Mr. M. And we are going over the Unit 1 free responses so that students who were struggling to understand why they did not get all the points will be able to understand the question and what Mr. Majewski was looking for. So, remember that each class had a separate free response question that was based on a different case. So I'm going to need to go through each of those separately in the same video. So you're going to want to probably move to your particular case at the point that I tell you to after we have reviewed the Mccullough and the Lopez decisions. Okay? So let's review Mccullough, then let's review Lopez. Then I will review each of the 4 class periods cases separately, one after the other, so you can move to whichever case you have for your class period. Okay, let's do this. Quite easy. All right? So, I tried to color code these post-its as well. All right? So, they kind of flow throughout in each of the cases. Let's go. So, we're going to start with Mccullough. All right, and we're going to start with a little background and remind ourselves of what the Mccullough decision tells us. 1. So remember that the Constitution lists the powers that Congress has. All right, these listed powers are often referred to as the enumerated powers. Okay, I'll generally call them the listed powers throughout this presentation. Now, they have them. They're written down. But there's also a clause that says Congress can pass laws that are, quote-unquote, necessary and proper to perform its other functions. This obviously seems to mean that Congress may have some implied powers that are not listed in the Constitution, right? And obviously this statement is known as the necessary and proper clause. So they have the listed powers, but it also seems they have these implied powers that are not listed. Okay, that takes us to Mccullough. So in the Mccullough ruling, Congress ruled, the court ruled that Congress does have those implied powers. That yes, those implied powers do exist. Yes, Congress has them. And once and for all, the court substantiates that, right? And that these implied powers obviously are not specifically listed in the Constitution. And Congress can pass laws to create or support the implied powers they think they should have. All right, so essentially, Congress can pass laws based on implied powers that they believe they have. But there are limits to that, right? Because Congress doesn't have the unlimited ability to do that. If challenged, Congress and the U.S. government, on behalf of Congress, have to justify to the courts why Congress needed that new law. And they have to show that that new implied power legitimately helped them to further one of the listed powers that is in the Constitution. So they've got to connect it back to one of their listed powers, and they've got to be able to show this implied power that we created with this law helps us to further one of our listed powers. And this is the one that it helps us to further, and this is how it helps us to further. So again, when Congress and the U.S. government on behalf of Congress, they want to use the necessary and proper clause anytime they want to justify giving themselves a power that they've created with a law, a power that's not listed, of course, then they have to prove a few things to the courts if they are challenged when they do. 1, they have to prove, again, that the law they passed helps them to support one of their listed powers, and they have to explain which power or powers is being helped by that, which listed ones, and they have to justify to the court how it's connected, that this new implied power is connected enough to the listed power. And not only connected, but number 2, that they have to prove that it's going to actually help them to support or improve their listed power. All right? So that's the job of the U.S. government. Now, if the courts agree with them and say, yes, we do agree with you, we think this is legitimate, then the law is constitutional, right? We go into this yes direction, and the law is constitutional, and it remains in place because the court has agreed that this was a necessary and proper law that supported another listed power of Congress. And obviously that would mean any state laws that differ with the national law, they would be overruled and they would be invalidated. Because remember, the Supremacy Clause says national laws are superior or supreme to state laws whenever they conflict. All right? So that's a win for the national government whenever the courts side with them and say that was a acceptable use of the necessary and proper clause. Now, of course, when the courts do not side with the national government, that means that they strike the law down, right? They declare it unconstitutional and it goes away. Because the court decided it wasn't a necessary and proper law that supported another listed power of Congress. All right? And that would mean, obviously, if there is no national law in conflict, then any state laws that differed with that national law, they would not be overruled and invalidated, right? Because the national law, is unconstitutional. And so the supremacy clause doesn't apply. The clause doesn't apply, and the state laws are still in place. So that's how Mccullough works, right? That there are implied powers, right? That if challenged, the government has to prove what the implied power is that they have created and how it is connected and helps with one of their listed powers. And the court's either going to agree with the national government and keep the law or agree with the challenger and invalidate that law. In Mccullough, remember, the case had to do with a bank, right? The Congress had had passed a law that created a bank, which, of course, wasn't listed in the Constitution, right? They claimed it was an implied power that helped them with taxing and helped them with trade. And so they argued they needed it in order to fulfill those other listed powers. And the court agreed with them. And so that set the precedent, right? That there are these implied powers. It's just the government has to show it. So let's move now to U.S. v. Lopez. And United States Lopez is about a couple of hundred years almost after the Mccullough decision. And so it's a much more recent case. And obviously we use it kind of as a contrast to Mccullough. And there's a reason for that, okay? And it'll be explained in this process. So in order to answer your question, you have to know Mccullough. You also need to understand the you need to understand the Lopez decision as well. All right? So in Lopez, Congress passed the Gun-Free School Zones Act, right? And that was a new federal law that gave stiff federal punishments for gun possession in and around school zones. And so if you were carrying a gun, right, you had one on you, you were subject to really, really harsh federal punishments, which means you would serve time in a federal prison. So there were some states and there were some legal scholars who believed the law might be a violation of the Constitution. Because they thought it might be giving the national government power over areas that would be traditionally reserved to the states. Now, what would be those areas? Well, one would be education, right? Because they're dictating what's going to happen in school areas. And the other was gun possession rules, because like concealed carry permits and those sorts of rules, those are decided on by the states. So in both of those areas, education and gun possession rules, states kind of felt like maybe the national government was overstepping its bounds. So why didn't the states challenge it, you might ask? Well, it would kind of look bad, maybe, to the people in a state if their own state government tried to overturn a law restricting guns in schools, particularly after there were some pretty harsh, shootings in schools, incidents. And besides, and this is a big one down here, the bottom green sticky note, one of the reasons why the states didn't really challenge it is they didn't know that if they had standing to, but more importantly, there hadn't been a successful challenge against the national government on these clauses in this case for over 50 years. The national government had won every single case where it had been challenged on this. So there was a feeling the courts were always going to side with the national government almost to an unlimited level. All right, so the state's attitude was more like, better wait for somebody else to challenge it who's actually been harmed or wronged by the law. Well, let's go to our third orange sticky note here, because that person is Alfonso Lopez. And remember, eventually he's convicted under the law for bringing a gun to his Texas high school. And so he appealed the conviction, and he argued, hey, that law shouldn't have been allowed to begin with. Only the state should have been allowed to make it because the national government had overstepped its bounds. And so I should have never been convicted, and you have to set me free. And so, of course, what happens then with Lopez? Well, we have to then apply what we learned in Mccullough to the Lopez case. So we've got to apply the same rules. One, does the law Congress passed help them to support one of their listed powers? And then, if so, which listed power and how does this law do so? And then number two, if that's true, will the law actually help Congress to support or improve their power, right? So what power is it connected to, and how is this going to help you to further your listed power with this law? So Congress' response in Lopez was, well, the law we passed, right, the Gun-Free School Zones Act, is a necessary and proper way for us to support our listed power to regulate commerce, which is trade. And our reasoning is that when guns are in schools, it restricts educational opportunities, which is going to slow down a person's ability to engage in trade throughout the rest of their life. And then our second reason is, well, if people know that there are guns in school zones in a particular area, they'd be less willing to go to that area to do shopping or other things because they might feel less safe. And so they'll avoid the area out of fear. And that would obviously potentially reduce trade or economic activity or commerce in the area. And so that was the reasons that the national government gave, right? You'll notice, however, they don't have an exact reason as to how guns, I guess you could say, specifically restrict trade or commerce in a school zone. And so that was an issue for them. And so the states obviously argued that there wasn't enough of a connection to commerce, right, to justify this law, and that the government didn't have a real connection, right, to the Constitution with this law, and so they were just trying to reach and make it fit within commerce so that they could be allowed to force it on the states. Well, this ruling is pretty significant because the court finally rules no. The law is unconstitutional, and it was struck down because the court decided it was not connected enough to the listed power, which was commerce, to be justified. And what was the reasoning of the court? Well, there was no mention of commerce in the law. There was no clear explanation of how commerce or trade was affected by this law or improved by its passage. And that meant, since the national law was unconstitutional, right, the Supremacy Clause didn't apply, and states could maintain control over this issue unless Congress passed a new law, which was ruled constitutional, which, by the way, is what they did. All right? So anyways, Lopez counters Mccullough, very significant. You'll notice the difference here, right, in the Mccullough decision, right? Obviously, we know the court side with the national government. In Lopez, we know the court sides with the states and restricts the power of the national government's involvement. All right, so let's take us now to our particular cases. And we're going to start with first period. If you are in second, third, or fourth, you might want to move forward, but I'm not going to spend a ton of time on any of these cases. All right, first period. So your case was Wickard versus Filburn. All right. You will notice I have the setup of this exactly the same way as it was for Lopez, right? In terms of the final results and the reasoning of the court and the arguments that the national government made. So let's start with Wickard v. Filburn. In this case, the United States government wanted to regulate the sale and the production of all wheat in the country, even on farms where the wheat wouldn't be sold for a profit, right? And that meant farmers in those states objected to that. They argued, hey, wait a minute. This wheat we're growing, some of the wheat we're growing on our farms is never going to be sold, right? So it's obviously never going to leave the state's boundaries. So national commerce powers and laws shouldn't apply because it's staying within one state. And if you follow the green arrows here, right, the commerce power, which is the clause in the Constitution that gives the government the ability to regulate interstate commerce. And by the way, interstate commerce is trade and any associated economic activity. So kind of economic activity in general. And so the question here in this case is whether this law actually regulated that something that should be classified under interstate commerce or not. Farm products that were never actually going to be sold, that were never actually going to probably even leave the farm. Interstate means involving two or more states, so any regular economic activity that crosses state lines in any way, right? Or can be expected to, or consumers of the product do, and so anything that really would involve the movement of people or goods across state lines, all right, for economic activity. So anyways, the case worked its way through the federal court system until it was heard by the Supreme Court, right? And of course, again, it's farmers challenging a national law, arguing that the states should have the power to make it instead. And the national government is going to now justify why they believe they have the authority to make it. So, same rules of Mccullough apply here. Does the law passed by Congress help them to support one of their listed powers? Which power and how? That's the national government's job to explain. And then number one, if number one is true, will the law actually help Congress to support or improve their listed power? That's for the court to decide. So, in this case, Congress's response was, hey, this law that we passed, right, to regulate the sale and production of wheat in the United States is a necessary and proper way for us to support our listed power to regulate interstate commerce. How? Well, agricultural activity is most certainly a part of interstate commerce, right? Crops are shipped to every state, and wheat is one of the most exported products worldwide. And secondly, knowing and being able to regulate the national production of products will affect the prices, the quality, and impact commerce massively, even if some of the total amount, right, the total production isn't ever sold. And so the government said it's important for us to know and be able to monitor and regulate total production, even for some parts that aren't sold, because the stuff that's not sold is going to affect the price, the quality, the quantity, the supply, the demand of the stuff that is sold. So, ultimately, did the court accept that explanation? Did they agree with the national government? In Wickard, yes. The law is constitutional, and it remains in place because the court agreed it was a necessary and proper law that legitimately supported the commerce powers of Congress. Farmers' arguments for state control over this issue were overruled. They were invalidated because since the national law applied, the state laws obviously were deemed not supreme. The national laws were supreme. And state decisions were inferior, and the states had to accept the national ruling and the national law. How does this compare back to Lopez? Well, let's pay attention to what we see over here on the right-hand side. How did the court rule, right? The court ruled completely in an opposite way, right? In first regard, right, in the one case they ruled that, in Lopez that it's unconstitutional. Why? Not a clear enough connection to commerce, and as a result, right, the supremacy clause wouldn't apply since the national law was invalidated. In Wickard, right, the law is constitutional. This was a necessary and proper use. This was connected and supported commerce enough for the national government to justify passing the law. And farmers' arguments were invalidated, and so state laws were inferior to the supreme national law on this topic. So your answer ought to have mentioned the fact that the decisions were complete opposites of one another and explained how or why they were opposite of one another related to the commerce part of this, related to the necessary and proper part of this, or related to the supremacy part of this. All right, hope that's helpful. Good luck. First period. Second period. It's time for U.S. versus Morrison. U.S. versus Morrison is another case that's covering, obviously, not only the necessary and proper clause, but the government tries to use the commerce clause to connect to it. So let's get right into the case. Okay, you're going to notice a lot of similarities with Lopez. This was kind of a softball question, if you ask me, out of the four. The United States government passed the Violence Against Women Act, which allowed some victims to sue their attackers for damages in federal courts. All right, okay, simple enough. Now, criminal justice, let's go up to our second orange sticky note here. Criminal justice is usually an area that's under the domain of the states, unless the federal government can find evidence of federal crimes, or they're requested by the state. All right, and of course the government here, right, remember, is going to argue that they can get involved in this because of their commerce power. All right, remember the commerce power gives the federal government the ability to regulate all interstate commerce. All right, trade, associated economic activity. Of course, the question here is whether the law regulated, again, something that should be classified under the category of interstate commerce or not. Right? Again, interstate commerce means two or more states are involved in the activity. If so, the national government can regulate. If it stays within one state, it's supposed to be under the domain of state regulation. All right. So, some of the inmates that were sued under this law challenged it, and they argued, wait a minute, this law is unconstitutional. It's an overuse of the national government's power. And the case made it all the way to the Supreme Court. And what these inmates argued is, this law isn't connected to commerce, right? But the government's going to use or try to use commerce as the reason why they should be allowed to pass it. But we just don't see how allowing crime victims to sue their attackers, right, is in any way improving or supporting the government's ability to regulate commerce or economic activity. And so it goes to the courts. And, of course, that means we got to apply the Mccullough ruling to it. Does the law Congress passed help Congress support one of their listed powers? Which power and how? And then again, number one, is it not just connected, but is it actually supporting or improving Congress's power? Well, Congress's response? The law is a necessary and proper way for us to support our regular listed powers to regulate commerce. All right. How? Well, they weren't really clear, to be honest. They kind of argued that maybe commerce should be involved in the amount of money that the crime victims would be receiving back. And since they were receiving financial penalties or financial amounts, that amounted to commerce. Okay? Ultimately, the Supreme Court rules here the law is unconstitutional, and they strike it down because they decided it's just not connected enough to the listed power of commerce to be justified. There was no mention of it. There was no clear explanation of how it was affected by the law or improved by its passage. And of course, that means since the law was unconstitutional, Supremacy Clause doesn't apply. States maintain control over this issue unless Congress passes a new law, which they did. They modified the law, actually, to make it work. All right. So again, if we're comparing this case back to Lopez, well, they're the same result with the same reasoning. And so your response should have indicated the court ruled the same way on this case. Specifically, they ruled the same way in regards to the necessary and proper clause and explained that, or how they ruled on the commerce clause, which all of this is obviously listed in the pink and the blue notes in the bottom of these Google Jamboards. Let's move to third period. So third period's case is another necessary and proper case where the national government tries to use the Commerce Clause to justify the law. The case is Gonzales versus Reich, right? It's a 2000 case and an early 2000s case. And the law is the Federal Controlled Substances Act, and the law regulated and controlled the production of illegal drugs, and marijuana was classified as an illegal drug. And of course, drug control is considered a national power, or a power that the national government does have. States obviously have drug enforcement powers too. Some states, like California, have passed laws that decriminalize or legalize marijuana within their states, right? And they argue that it shouldn't be classified as an illegal drug, right? And so the national government's definition of it and the state's government's conflict right now. And so the government passed the Federal Controlled Substances Act, and it specifically said we can regulate marijuana just like we would any other illegal drug. All right, well, Reich was convicted. He was a Californian who was convicted under the law for possession of marijuana plants. They were for his own purposes, so they weren't going to be involved in commerce in any way. He appealed, arguing the national government overstepped its authority because he never was going to sell any of the product. He was only going to use it, so how could it be involved in commerce, especially in a state that had said it was legalized? The government, of course, used the commerce power to justify the law. And they argued that, of course, the commerce power comes from the clause, as we've said a few times before. It gives the federal government the authority to regulate all interstate commerce, which really just means trade and associated economic activity, right? Now, here's the thing. The question here is whether this law is actually regulating something that should be considered part of interstate commerce, because interstate commerce means moving between two or more states. And so his argument is it's never going to leave my state, so why in the world should I be subject to this law? I shouldn't be, it's unconstitutional, and I should be set free. All right, let's take it to the right side of the board, and let's weigh in with the Mccullough rules. So first off, Congress, you got to prove to us the law Congress passed helps to support one of your listed powers. If so, which power and how? And then number two, does it actually support or improve that power that you have listed? Well, of course, same as in the other cases, Congress's response, the law is a necessary and proper way for us to support our listed power to regulate interstate commerce, trade. And their explanation: extra-legal drug, illegal drug activity most certainly affects legal interstate commerce and drugs, and illegal drugs are often shipped through legal methods. And marijuana is one of the most widely distributed drugs. So, of course, they argued, it falls within our realm to be able to regulate this with one of our implied powers. Being able to control the national production of marijuana is going to affect supply and demand and prices, and therefore it's going to impact illegal drug commerce massively, even if some of it isn't sold. And so they argued we have many, many reasons why this law helps us to better regulate commerce in the country, specifically based on legal and illegal products, right? Narcotics. Did the Supreme Court accept this explanation? Yes, they did. The law is constitutional, and it remained in place because the court agreed this is a necessary and proper law that legitimately supported the commerce powers of Congress. And so therefore Reich's argument that the state should have control over the issue were overruled. They were invalidated because, of course, the national law is supreme to the state ruling in this issue. So again, federal government does have the authority to close down any one of these marijuana places in any state where it is legalized, no matter the circumstances, should they choose. Comparing that baby to Lopez, right? What do we notice? Opposite. Right? In Lopez, of course, the court ruled against the national government. It ruled in favor of the states. It ruled that it was an unnecessary use of necessary and proper. It ruled that it wasn't connected to commerce, whereas, of course, it ruled that the national law was not supreme, whereas in Gonzales, right, the exact opposite. It is a necessary and proper use. It is connected enough to commerce to be necessary and proper law. And, of course, that means the federal law is supreme to the states. Okay, we're moving it back now to fourth period, our last class period of the day. And, of course, your case was a little different because your case doesn't involve the commerce power. Yours is the only case that did not. So I'm going to take you back again really quickly to the Mccullough decision. And I want to remind everybody of the Mccullough, findings. Implied powers do exist, right? And specifically, I want to draw your attention to this orange sticky note to the right here. Remember, in Mccullough, Congress created the bank, and it helped them to collect tax money. It helped them to trade. Even though there was no listed power to create a bank in the Constitution, right? They argued it helps us with some of our other listed powers. And that was accepted, right? Because they were able to connect it enough to the listed power. Okay, so let's compare that to this case, all right? Because it's the same as the other cases, it's just not using the commerce power. They linked this law to a different one of their listed powers. So anyways, they passed the Child Protection and Safety Act, Congress did. It allowed the government to hold federal prisoners even after their sentences, if they were deemed a special threat to the public. Now, both the federal government and each state have their own systems, their prison systems, right? And federal prisons are located in different states around the United States. But some of those states where federal prisons are located don't allow their prisoners to be held after their sentences, all right? And so some prisoners that were being held there, final orange sticky note, beyond their sentences, challenged that law, and they argued they were being unfairly incarcerated and they should be freed. Well, the national government does have something called the security powers, right? It's from a clause in the Constitution, a series of them actually, which relate to national security safety. Okay? And it gives the federal government the ability to protect public safety, but states also have the ability to do the same within their boundaries. So the question here is whether this law regulated something that should be classified under the category of security, public safety, or not. And if it was, then the national government has the ability to do this because they're able to list it, or connect it, I should say, to their listed powers clearly enough. Now, the challengers argued Congress should just pass a law. If they wanted to fix this, they said, you should just pass a law to increase sentencing standards if you want to protect the public, instead of just keeping people beyond your incarceration. So they said, hey, you have the ability to fix this, Congress. You can just pass a law if you want to. That increases punishments. Why don't you do that? All right. Otherwise, right, it sure seems unconstitutional. Well, let's go, remember, to the rules of Mccullough, and let's apply them to Comstock. So does the law support a listed power of Congress? Which one and how? And does it actually support or improve that power? Well, Congress's response, remember, this is a necessary and proper way for us to support our listed power to regulate safety and security. How? Only high-risk offenders for certain crimes who are deemed a special threat can be held because the government views them as unique threat to security and safety. And obviously that would mean the law would allow the government to improve and strengthen its safety and security laws, right? Ultimately, is this reasoning acceptable to the court? Yes. All right. The court says yes, the law is constitutional. It remains in place because the court agrees it is a necessary and proper law that legitimately supported the public safety and security powers of Congress. And so any state laws or decisions that violate the federal law are overruled. They are invalidated because the national law here is supreme. All right. So ultimately, this meant that states had to follow the federal ruling when it dealt with federal prisoners, even if those prisons were located in their state. So as you can see in both cases, right, we have the court siding with the national government and agreeing there were implied powers here and agreeing this did fit the necessary and proper rules, and therefore the law was justified. Right, and both laws were justified, and any state laws or actions in violation were inferior and invalidated. So, folks, those are the 4 cases. Now, hey, I gave you the reasoning in the case that you had to focus on, right, in your specific case. You didn't have to even give me the reasoning in that case. All you had to do was essentially say to me, how did the court decide? All right. I give you a lot more information in these Jamboards than you actually needed. All right. These additional blue slides here on each of these, you didn't even need to mention in your response. All right. All you needed to do was explain the decision of the court and whether they were the same or whether they were different on these issues on necessary and proper. All right. So honestly, look at the sticky notes. If they're both green, that means the court agreed, right? If they're both pink, right, that means the court agreed on those as well. But if one set is green and one set is pink in the bottom right, then that means obviously there was a difference in opinion, and you need to explain that. All right, my friends. Hopefully this was helpful to you. Please reach out to me if you still are unsure why you got the score that you got.